Now, guys, let me start this episode with a question. Now, in this question, I'm going to ask you to imagine that you are a doctor, a senior doctor. Now, imagine you're a senior doctor and you just received a patient sent to you by a junior doctor after the patient has been treated by the junior doctor. Now, obviously, you're not going to be fully satisfied with the way that the junior doctor treated the patient. You won't be fully satisfied because nobody is fully satisfied with the job of somebody else that somebody else has done when we could have done the job ourselves. Everybody has their own style and ways of doing things, so it's natural for us to not be fully satisfied with how other people do things. But as long as the difference between how we would have done it and how the junior doctor did it is roughly the same, the differences are small, then we should not dispute the competence of the junior doctor. If, for example, we would have made 10 stitches operating on the patient, but the junior doctor just made 8, or if we would have given the patient 10 milligrams of drug, but the junior doctor gave 12 milligrams, this should not really be a case for us to question the competence of the junior doctor, because they did what we would have done, except they did it to a degree that was not exactly in the degree that we would have done it. But if we would not have done an operation at all, or given the patient any drug, or if we actually think it's wrong to conduct an operation or give the patient a drug, but the junior doctor did not think that there was anything wrong with what they did, this is grounds for us to question the competence of the junior doctor, isn't it? If your junior doctor is doing something that you would not have done or think it is completely wrong if you were to do it, should the junior doctor even be allowed to serve as a doctor? What if they treated a patient in a completely wrong fashion? If they already treated one patient in a completely wrong fashion, the chances are high that they will treat other patients in a completely wrong fashion too. That being the case, shouldn't it be your responsibility as a senior doctor to recommend that the doctor be fired or at least taken or pulled out from their job so that they don't do any harm to anyone else in the course of doing their job? As it is with doctors, shouldn't it also be with judges? Now, take the Syed Saddiq case, for example. Roughly 2 years ago, in November 2023, Syed Saddiq was found guilty of abetting a criminal breach of trust involving more than 1 million belonging to Bersatu Youth. He also had another count of dishonestly misappropriating property totaling 120k, also belonging to the youth wing. Syed Saddiq was also convicted on 2 counts of money laundering for transferring a total of 100k to his personal account from a company linked to the youth wing. It's called Armada Bumi Bersatu Enterprise. He was sentenced to 3 years in jail and 1 stroke of rotan on the CBT charges, 2 years in jail and another stroke of cane for the misappropriation charges, and another 2 years jail for each of the money laundering offense. In other words, the trial judge that gave the verdict on Syed Saddiq's case found him guilty on all 3 counts. The trial judge, Judge Dato Azhar Abdul Hamid, in his written grounds of judgment, which he delivered 1 year later, last year in 2024, November 2024, the judge would even double down on the sentence he handed out to Syed Saddiq a year earlier by stating that the 7-year jail sentence, 10 million ringgit fine and 2 strokes of cane were justified. He noted the intention behind the actions and considered that the former Muda president's status as a public figure and a role model for youth, citing the 1977 case of former Selangor MB Datuk Sri Harun Idris. This is what the judge said. As a parliamentarian and an idol for youth, it is only appropriate for the accused to be held to a higher standard, set a positive example for others to follow, and fulfill the responsibility of being chosen by the people of Muar to represent their rights. This is what the judge said. Azhar also said the court cannot accept Syed Saddiq's defense that he never instructed the members to withdraw 1 million and denied knowledge about it. This is what the judge said. It is unreasonable for him as a former chief to say that he does not know a large sum was withdrawn. For the dishonest misappropriation of property and money laundering charges, the accused said the money from the fundraising was to reimburse what he had spent previously, but no evidence was presented to back up the defense. This is what the judge said, yeah? Today, 25 June, however, a three-member Court of Appeal panel led by Justice Dato Ahmad Zaidi Ibrahim and which joined by Dato Azman Abdullah and Dato Norin Badaruddin not only unanimously overthrew the verdict by the High Court judge against Syed Saddiq, they overthrew it on all three counts. So let me repeat that. Three of the Court of Appeal judges unanimously, no dissent, yeah, unanimously threw the High Court judges verdict. Not just one, yeah, all three of it. Delivering the court's decision, Justice Norin would even declare that the High Court judge, Dato Azam, had erred in several decisions and that there was no element of dishonesty when the former Youth and Sports Minister instructed his staff to remove money from Bersatu's Youth Armada's bank account. She said the trial judge did not take into account the procedures and contradictory evidence and also took into account evidence given by witnesses under duress from MACC. She added that the instruction to withdraw the money at the time were based on valid concerns and his conduct, in other words, Syed Saddiq's conduct was reasonable as he was legally entitled to the money. This is what the Dato Norin, the Court of Appeal judge, said. The learned trial judge did not look at the evidence on all grounds and we consider the non-direction of the learned trial judge amounts to misdirection, yeah. He also said, we reviewed and found the judge failed to consider all the evidence in the case and there was a serious lapse in the decision-making process. Serious lapse. The judge must explain how his logic considered all the evidence presented in the defense. In other words, the three panel Court of Appeal judges not only unanimously acquitted Syed Saddiq on all three counts that he was earlier found guilty, they are saying that the reason they are acquitting him is because the trial judge had seriously erred in making his judgment. Now, I'm no legal expert, but from a common sense point of view, if three of your superiors are unanimously saying that you seriously erred in doing your job, to the point, three of your verdicts, all of it was overthrown. Although you insist that you are completely right, even after you thought about it for an entire year, should you still be allowed to continue doing your job? Think about it from a common sense point of view, yeah? We do realize that in no other job this will be allowed, right? Not only as a teacher, police officer, soldier, or even a purchasing manager at a private company. If you did something that you thought is right, even after you thought about it for 1 year, but your superiors, not one, not two, but three of your superiors think that you have seriously erred, shouldn't you be considered incompetent and taken off your job, lest you cause a lot of damages or harm because of your incompetence? A judiciary is called an institution. To be an institution, all the members of the judiciary are expected to be trained, indoctrinated, and conditioned to have a common principle, ideal, or value that the institution has. Everything that you consider an institution, be it the military, the police, a school, a university, even a religious order, has a concept of training, indoctrination, conditioning to ensure that the opinions, views, expressions, conduct, and actions by its members are in tune with the institution's values, principles, and ideals. The more higher ranking a member of an institution is, the more accurately that everyone will expect that their views, opinions, expression, and actions represent the values, ideals, principles of the institution. If you're a teaching assistant who just joined a school a couple of months ago and you do not really fully, and your actions or expressions do not really fully represent the ideals of the institution, that is acceptable. It is acceptable because you're new. But by the time you become the head of the department or the vice principal or the principal of the school, you obviously are expected to represent the ideals of the institution in a more accurate fashion. If you represent the ideals of your institution in a more accurate fashion, your views, expressions, conduct, actions are expected to be more or less aligned with the views, with the values, with the not only with the values, ideals and principles of your institution, they should be aligned with the views, opinions, conduct, expression and actions of all the other higher level members of your institution. Obviously, no one expects all the higher high members of the institution to have the exact same views and opinions. But the differences that the higher members of an institution are expected to have are not expected to be fundamental. At least when it comes to a run-of-the-mill case like that the institution deals with on a regular basis. A criminal breach of trust is hardly a special case for the courts. That being the case, for 3 Court of Appeal judges to find the High Court judge to have seriously acted in coming up with this verdict on such an ordinary case, to the point that they overthrew 3 of his verdict, when the High Court judge himself believes that he was absolutely right in coming up with a verdict in the CBT case, even after he had thought about it for 1 year. Should be raising the question of the institutional integrity of the judiciary, isn't it? If there is institutional judiciary, say for the police, how a policeman will behave in Perlis will be roughly the same of how a policeman will behave in Johor, in Sabah, in Sarawak, anywhere, roughly. If they are not behaving in roughly the same way, where is the institutional integrity here? If everybody in the judiciary is just doing whatever they think is right, then are they an institution? If the judiciary is an institution, then why are their top-ranking members having such a divergent opinion on such common cases like CBT? Now, this is something we have to think about. This is something that we have to seriously think about. This is something that the judiciary should seriously be thinking about. Anyway, that's all I have for you guys today. Catch you again soon. Have a good day, guys.